technical difficulties that we experienced earlier. Thank you so much for your patience. Um, I just want someone online to indicate if you can hear us clearly.
Yes, I can hear you.
Wonderful. All right, so thank you for joining us for this important discussion today on improving labor legislation in Barbados. We bring together some diverse perspectives from across labor relations to examine where we currently stand and how we can collectively move forward. I'm joined here today by Kristin Turton, Kamisha Benjamin, and Stacy Hastick is online. These are our distinguished panelists. Kristin Turton is a legal powerhouse whose career spans multiple areas of law, including employment relations, civil litigation, and contract enforcement. As the principal founder of KCT Chambers, she has successfully represented clients at every level of the judiciary, from the Magistrates Court to the Caribbean Court of Justice, driven by her unwavering belief in fairness and accountability. Beyond the courtroom, Kristin has served as chairman of the Severance Payments Tribunal, former vice president of the Barbados Bar Association, an educator at the University of the West Indies, and an advocate for workplace rights. The BEC, supported by the ILO, engaged Kristin as the lead consultant to analyze Barbados's labor laws and synthesize employer contributions to much-needed reform. Help me welcome Ms. Turton here with us today. We also have Kamisha Benjamin, an attorney at law with over 10 years of legal experience and a deep passion for social justice. Her unwavering commitment to fairness and equity naturally positioned her as a powerful advocate for workers' rights across Barbados. She currently serves as Deputy Director of Industrial Relations at the Barbados Workers Union. Her work includes negotiating improved employment terms and lobbying for progressive labor legislation. She has also influenced reforms within the Labor Department to better serve Barbados's working population. Welcome, Kamisha. And finally, we have Stacy Hastick. She's a Grenadian labor management consultant and founder of Carry Labor, an AI-powered platform helping employers, employees, and stakeholders navigate labor laws across the CARICOM region. A former executive director of the Grenada Employers Confederation and member of the Labor Advisory Board, Stacy has contributed to key local, regional, and international initiatives, including the revision of Grenada's labor code and the World Bank's Doing Business report. Now based in Barbados, she brings practical experience and expertise and a knack for harmonizing people, policy, and purpose to help strengthen Caribbean workplaces. I now turn over to each of our panelists, starting with Kristin, then Kamisha and Stacy to share brief opening remarks. Welcome, ladies.
Good morning, Patricia. Good morning to everyone online. I'm grateful to be a part of this discussion because there has been so much development in the area of employment law in the last 15 years. I think we've had more development in that area in the last 15 years and since inception. And ultimately, I'm happy to be a part of the process to do that. I think one of the things we focus very heavily on is making sure that employees have been granted rights that have been spoken about, but which were never codified. And it's important that we do that, but we also have to do it in the context of the businesses in which they work. And I think one of the things that we really have to focus on is striking that perfect balance between making sure that employees have rights, but that employers are able to provide those rights to them, making sure that there are businesses that can still function in the face of those rights so that people can actually be employed. And when we modify our laws to allow that to happen, that is when we will know that we are doing labor law the right way.
Kamisha?
So good morning, everyone. I want to wish you guys a happy BEC week.
Thank you.
Funny enough, right now I am in agreement with Kristin. It's not often that way, but I do believe that we have a lot of work to be done. And so I am grateful to have this opportunity on behalf of the General Secretary to be a part of this conversation. I'm hoping that this conversation may trigger the actions that are necessary to improve labor in Barbados. So looking forward to the discussion.
Thank you. So over to you now, Stacy, for your opening remarks.
Hi, good morning, everybody. Hi.
Hi, Stacy.
I am very happy to be a part of this discussion. As someone coming from Grenada and settling in Barbados, it's always interesting to see the inner workings of labor and employment relations in a country. And I think it's a great opportunity for us to look at what currently exists, what we can change, and how we can make employer relations more conducive to economic development for Barbados. And I guess the spin-off would also reach within the Caribbean region, because then the Caribbean region can look to Barbados for new changes and development in the industrial climate. Thank you.
Thank you so much for that. So I want to begin with a broad overview. Understanding the current state of our legislation in Barbados is critical to ensuring that any reforms are evidence-based and they're targeted so that it addresses the most critical gaps that we currently have, right? So considering this, I want to ask Kamisha first, from your unique vantage point, how would you assess the current state of labor legislation in Barbados in terms of its effectiveness, fairness, and responsiveness to workplace modern realities?
So I would say this, Patricia, as Kristin indicated in her opening remarks, there is no lack of legislation. But as you rightfully asked in your question, how effective is it? And so I would say that the union recognizes, for example, that the Employment Rights Act is a significant step in codifying fundamental rights, such as protections against unfair dismissals, for example, and the right to written employment contracts. Those kind of necessary steps were taken for employees. However, that same piece of legislation gave birth to the Employment Rights Tribunal. So I would like to start there. The process in getting to the Employment Rights Tribunal is plagued by delays, under-resourcing, and in our view, sometimes inconsistent rulings. And those things tend to undermine the confidence of workers in seeking redress. So that is one area that it's our view can be improved. Let me put it that way, improved. And in looking at that, we can't just look at the tribunal. We have to look at the process that gets us there. And so when we look at the Labor Department and how they are resourced, any worker in Barbados, let me put it this way. I've been with the union from 2020, and I can count on one hand the number of times that we have had decisions at the tribunal level. And it's not because we haven't been escalating matters that need to get there, but it is because of the significant delay. And the matters that I was able to conclude were matters that predated me coming to the union. So I took up matters that had already been there. So that would tell you the kind of delay that we have in the system. And justice delayed is justice denied, right? I genuinely believe that. And so we really need to look at how that can be improved. Now, I know we've heard the minister say that plans are in place for, the tribunal to sit consistently, and we look forward to that. But up until this moment, as we are speaking, it has not happened. Also, there's the need for regulations. So I also understand that, the idea was for lay people to be able to approach the tribunal. In order for that to be possible, there needs to be some guidance, because right now the law is very vague. And there's no enforcement. So yes, there are timelines, but nobody respects them. And when people don't respect them, there are no consequences. That is a problem. So in my view, that as much legislation as we are pushing out, if it cannot be effectively policed and monitored, we still have a problem. In terms of effectiveness as well, and I'm sure we'll get into this as the conversation goes on, but there was a landmark decision that came out of the Caribbean Courts of Justice, the Shafet decision, Shafet and Orlando Harris. And essentially, that decision limited the tribunal's ability to offer compensation in a meaningful way. That's my view. And since that decision, there's been no amendment to the legislation to fix that. And people have been weaponizing it in terms of, if I know that whether I settle because I know I'm wrong at the conciliation stage, or I carry it all the way through the tribunal, the compensation you get will be the same. I mean, an upstanding employer wouldn't think like that, but we know that when we treat into these matters, it's not generally with upstanding employers. And so that too is something that, in my view, needs to be addressed.
Thanks for that, Kamisha. I want to circle back a bit to the legislative part of it, right? Kristin, you have engaged in a comprehensive review of some of our key pieces of legislation. So I want you to speak with us on the current fragmentation of our legal framework, and how it impedes efficient resolution of disputes and so on.
I think ultimately we have several pieces of legislation that govern employment law, and of greater concern is the fact that some of those pieces aren't even employment law pieces of legislation specifically. They are things to do with whistleblowing, which applies in a broader sense to prevent corruption, but yet it includes provisions for that employers have to abide by. Data protection legislation is another example. And discrimination, the new rights of persons with disabilities legislation, all of those have broader purposes, but contain requirements that employers have to satisfy and rights that employees are entitled to have. And it is good that rights exist in relation to those things and protections exist, but who knows to look there? And I think that's part of the challenge. Part of the challenge that employers and employees would equally face is that they will never really know whether they are aware of all of their responsibilities and all of their rights. And that is what happens when you have a fragmented system. That's one thing. But then you also have other laws which overlap. So you have legislation that deals with health, safety and health at work, and legislation that deals with occupational safety. And both of those pieces of legislation talk about having to maintain registers of injuries that take place at work. And yet they're different registers. Why do you need two? Right? You have, for example, you have the Employment Rights Tribunal created by the Employment Rights Act, and that is supposed to address issues including workplace discrimination. But yet you have another tribunal created under the Rights of Persons with Disabilities Act that is supposed to govern discrimination involving disabilities. Where does the employee go? What do they do? What do they know? And then to Kamisha's point, there's a lack of regulation and a lack of real legislative support for addressing basic things like the jurisdiction. So how are they determining jurisdiction? As in, who is capable, which tribunal is capable of hearing this particular grievance? Right now, we have lots of legislation that speaks to rights and responsibilities, and we're happy that they exist. But because you have those overlaps, even things as simple as the definition of employer under the Employment Rights Act is one thing. But then there are 5 or 6 different pieces of legislation, even the Trade Unions Act, where that's different. Same thing for employee. There are some pieces of legislation that speak about employees one way, and then another piece of legislation that will tell you that independent contractors are to be considered employees for these purposes. That is the result of there being no cohesion in the legal framework as it relates to labor law in Barbados. And it creates confusion. It can create delays. It can cause people to lose their rights because they take incorrect paths, and to not, or because they don't know about them. And that's something that we need to change. We need to change it by putting it in one place where everybody knows this is where the law is, this is what the law is, and this is what I am required to do, right? Or this is what I am entitled to. And until we do that, we're going to continue to have a confused system which boasts of rights that nobody really has access to.
So I want to add a little bit onto what you noted, because you focused heavily on the knowledge access and the knowledge management part of it. But can you explore the impact it has on small to medium-sized enterprises, this segmented manner, and because even when they know, it's still segmented and there are a lot of requirements that still is kind of cumbersome. So can you explore a little bit or expound more on that for us?
So the impact on small businesses, yes, fragmentation affects them, but I think there's a broader issue. The broader issue is that these laws are created with the employee exclusively in mind, and no contemplation of the structure or nature of business that has to provide those rights to those employees. So when you have a smaller business and you say to them, okay, you have to appoint a person who's supposed to receive and investigate complaints from whistleblowers, and that business has 2 employees, who's doing the reporting and to whom, and what time are they going to have to do that, right? Then you look at a business that has, let's say, 5 employees, and the person who runs that business, they're not just a business owner that's watching other people run their business. They're actively involved because they started that so they could just make some money to survive for themselves and their families. And they said, I need help in order to do it the right way. And that's great. But when you say to them that they have to adopt onerous disciplinary procedures, or they have to have 10 different types of registers to protect employees or to make sure that their rights are protected, or that for a person who has a disability, you have to make sure that you provide them with reasons for why you haven't employed them, when you are trying to get somebody to help you quickly, right? That creates an undue pressure on them, and one which is not mitigated by anything in our system at all. We do not have any support for them whatsoever. I remember Kamisha raised the issue of the Labor Department and under-resourcing. But I also think it's a question of what's their overall purpose? If their overall purpose is to help labor, to help people to be able to work in safe, comfortable, and fair environments, they can't just focus on receiving complaints. They should also be focused on creating a system where, let's say, small enterprises that cannot have an HR officer or afford to pay an attorney for every question, where they can go somewhere and know, well, this is what I should do. This is the process that I should follow. These are the policies that I must have, even specimen policies, something like that. When we talk about regulations and the process for applying, let's say employees need to know, for example, how do they make a complaint? And when they make a complaint, how do we know that it was made? Is there a form? Right? Will the employer, this small business, you receive a call from the Labor Department and they tell you that this person made a complaint. When? What evidence is there of that? Was the extent of the complaint?
How long ago?
Right? How long ago was it made? Do I have guidance as to how I should respond? Is there a form that I can fill out? No. So those are the things that we have to look at legislatively, right? In terms of regulations, and also in the overall structure of the Labor Department to make sure it supports everyone that's involved in this employer-employee relationship.
Thanks so much for that, Kristin. So I want to turn it over now to Stacy, who's online. You are currently now practicing in Barbados, right? Which is, I would assume, completely different from the realities of Grenada. So what has been your experience navigating and practicing here in Barbados, considering your transition from Grenada?
Okay, so one of the things that I noticed here in Barbados, one of the first cases that I dealt with had to do with an employee who had an issue at their workplace, which made its way to the Labor Department. One of the things I noticed is that we were in the height of the pandemic, I should say. So most of the activities were transferred to online, which I think is a positive, and it's very good for Barbados and the Caribbean generally. One of the things I noticed was that in some instances, when you take matters to the Ministry of Labor, because there is I would term it a high turnover of staff, in my opinion. You recognize that sometimes the issues, there is a delay in the issue because the new staff has to get acquainted with the issue as well. And that kind of sets the process back a bit. And I think that's one of the key takeaways that I noticed from my time here. Also, when dealing with employers, I recognize that the process that some of the employers follow, because you can appreciate that not all employers are associated with the big associations like the Barbados Employers Confederation and Chamber of Commerce. So they might not have the guidance that they need to go to basically carry out their processes. And I noticed that there were some gaps in the way that employers actually the practice versus the legislation. The legislation might ask for you to comply with certain requirements if you're filing a grievance, if you're conducting a disciplinary hearing, and you find that employers don't quite have a handle in some instances on how to navigate these processes. And when this happens, what happens to not only the employer, but also the employee, you have a process that becomes, you're unable to move forward with the process because of the mistakes. So even if the employer was in a position where essentially, on principle, the employee needed to be disciplined accordingly, because of the process, then the entire process essentially is not valid. Probably I can say that because there were mistakes in the process. So that's something that I noticed here in Barbados. Not saying that Grenada is perfect and it doesn't happen, but I think that more guidance is needed for employers when they're dealing with disciplinary issues so that they don't meet all those roadblocks in actually handling issues, because it does inherently impact on further issues. Because if you have one person getting away with something, when it happens again, they would say, well, essentially, this employee was not treated in the same way. This process wasn't followed in the same way. And essentially, it can cause more headaches for the employer and employer as well. So those are some of the issues that I noticed.
Right. So your view basically aligns nicely with what Kamisha and Kristin had noted. So I want to dig a little further into your experience in Grenada, into the Grenada experience, right? Because you guys have recently had reform, right, of your labor code.
Yes.
So, and I believe that for us to get where we need to go, we can look also at previous models so that that can help guide us, right? And we can avoid certain missteps and take all the good parts from what other places have done. So I want you to share with us what were some of the primary drivers that led to the reform, the labor code reform in Grenada?
Okay, so great. So one thing I would like to state is that this process is actually still ongoing. And that has been the case in many revisions that I've noticed, not only in the Caribbean at the country level, but even when you look to CARICOM, there are a lot of legislations that they're seeking to push forward, but because of political will and other issues, it's unfortunate it can't be pushed through as you expected. Nonetheless, the labor review process in Grenada, it started somewhere around 2014. I was at the Employers Federation at the time, and we were engaged by the government initially to have discussions with a consultant from Canada. One of the drivers, I would say some of the drivers to the legislative review process was that Grenada needed to have a legislation that was balanced. There was a belief at the time that the legislation was skewed towards the employees, and there was a need for the legislation to be balanced in some ways. Apart from that, there was a requirement that the Grenadian government or the country of Grenada meet international labor standards. And so the review process acted as a medium through which Grenada can look at all the pieces of legislation that currently exist and look at the gaps. What are some of the issues and how can we rectify it? How can we get it up to mark? Another issue that sparked the review was the need for Grenada to be competitive. What is your legislation saying about you as a country for not only workers, but for investors, for persons seeking to set up shop in your country? Do you have a progressive labor legislation? Is your legislation going to cause problems for a person who is looking to invest? I'm not saying that this is a way for it to be pro-investors only, but you need a legislation that is balanced and that can meet the needs of what you need for economic development. And so also the legislative process served as a means through which employers and the unions and government as well as the facilitating party can come together and look at the areas of contention, possibly. And in this process, we found that there were many issues in which we delved into as an advisory board. Now, there are a lot of moving parts in this legislative process, and I think at the end I would highlight some of the lessons because it's important for Barbados and any country who is seeking to do legislative review. So some of the areas that were highlighted were contracts, leave entitlements, family responsibilities. There was an issue of the right to recall. When you look at different, the definition for employer, the definition for independent contractor, there's also, let me just make sure I'm not missing out anything. In terms of termination pay, there were some issues regarding that. Then there was an issue of the right, something called sympathy strikes. I think the unions are very aware of that. We spent a lot of time discussing the term of sympathy strikes and whether or not it is something that needed to go into the legislation, whether or not we needed to leave that out. Essentially, it wasn't an area that the employers or unions agreed on, but there were a plethora of issues that were highlighted. For example, one that we had lengthy discussions of was section 66 in the Labor Relations Act of Grenada, which spoke about a reasonable time period. In law, I'm not a lawyer, but I know in law, the term reasonable period, reasonable time is something that is oftentimes used as what someone would deem as a reasonable period for specific issues. Don't quote me on this, it's just my general understanding. So we had a lot of discussion about what is a reasonable time. The unions were saying 7 days is suggested as a reasonable time, so let's put that in the legislation. Apart from that, the employers were not going to agree because based on the industry that you represent, a reasonable time fluctuates. It might be easy for a clerical staff, a service industry to get back up, but a manufacturing business, a business within the manufacturing sector would take a lot more time to get back moving. And then we had that case with the Grenada Brewery, and you saw what happened. Well, I'm taking for granted that you all know, but you can Google it. You can definitely Google it. It's Grenada Brewery issues. It's good for anybody who's interested in labor relations. Moving along, because I know there's a lot of time. There's not a lot of time here. So there was quite a lot of issues brought up. And so that's essentially why we had the labor review process.
Thanks so much for that, Stacy. So I want to turn over now to Kamisha. Given Barbados's context, what are your thoughts on a similar type of plan and what stakeholders do you believe should be at the table if we had to do a reform?
I would say, Patricia, I think we currently have a pretty good model in terms of Barbados has the social partnership going, and it is pretty effective, I would say. So it's just a matter of bringing the particular issue to the table at the social partnership so everybody could kind of weigh in and we can determine what the way forward should be. I want to tap to something that Kristin said earlier. She made the point that the fragmented approach can be onerous on small to medium-sized enterprises. And I agree, it could be, particularly because if you go right now and you Google certain pieces of legislation in 2025, it's not easily found.
Correct.
And if not even just the legislation, worse yet, the regulations that go along with the legislation. So if you don't have the ear of an attorney like Kristin, or you don't have a relationship with the union who may be able to guide you, then I can see how small to medium-sized enterprises could genuinely be lost as to what are their responsibilities. So I agree with that. However, I would say that on the other hand, there are a lot of employers who choose to be rogue, who know very well what is expected of them and choose not to comply. And those will be the ones where the union, for example, may go to a meeting today and advise them, this is what the legislation says, point it out. Why tomorrow we gotta do the same thing? So while I appreciate that there are some concerns for the small to medium-sized enterprises, I don't necessarily think that that is the issue when it comes to compliance. So, this is Kamisha now. This has not been the union's. This is not the union's perspective necessarily, but I don't think there would be an issue or should be an issue to the approach of having a code. Is it priority right now? Maybe not. That's my view. I think that even if you put everything in one place and you can't enforce the provisions, what's the point? So I think we need to really focus on that, focus on making our labor department more robust, give them the teeth to be able to really effect change, because essentially they will be treated as like a sieve. And right now the sieve has holes, right? So we need to mend that, but that's my view overall.
Okay, thanks for that, Kamisha. I want to circle back to Stacy, right? Because as Kamisha just said, she does not think that the code is really the instant answer. But I would like for you to share some lessons learned. So share with us how the revised code impacted employer-employee relations and like dispute resolution in Grenada up to the point where it had with what you had concluded, because you said it's still going on, right? So up to the parts that were concluded or resolved, share with us how it impacted the employer-employment relationship and the dispute resolution mechanisms in Grenada.
Okay, so what I can say about the review process and how it affected the labor relations climate in Grenada. One of the things I would like to circle back on is the fact that during the process, we took a tripartite approach, similar to what Kamisha indicated, in which we had the employers, the unions, and the government as the facilitating partner. And one of the things that we realized is that from the discussions, we were all in agreement that there needed changes to be made in the legislations. From each different perspective, we had issues that were priorities. But I think one of the key lessons in that entire process is to recognize this legislation is not only for employers, it's not only for workers, it's for the entire country. And so in some instances, in your negotiating, you might go hard for certain instances, but there are some issues that you need to take a step back and say, for country, okay, for country. Because at the end of the day, we're all operating in the same environment. If an employer decides that they're going to close up shop and leave, let's say you have 200 employees, you have 200 employees out of a job. And then you have 200 employees who cannot actually buy things. And then you have shops who need these employees to buy things suffering. So you actually need to look at the greater good. I will say that during this process, what we've learned is that when you're negotiating with government, when you're negotiating with the union, it is important it's important to be mindful of what you decided on, what you agreed upon, and what you did not agree upon. And so in that process, we found that if you don't keep proper records as to what the legislative process, what happened during different sessions, what we agreed upon, you would be essentially turning in circles because you're coming back to the same issues over and over at the meeting. There are some issues that you would agree on, and that's great. And then there are some issues that from the employer and labor union perspective, we left up to the government to decide. And these are like some of the key lessons that I would learn and not that I learned in that process. Another instance is if you're embarking on this labor review process, understand that there are multiple actors in this environment. Look at persons that you can collaborate with to avoid duplication of efforts. In some instances, you have 3 different organizations doing the same thing, and that is a waste of resources. If you can pull your resources together, you are going to find that you have much more quality results in the work that you're doing. One of the things that we did is that we collaborated with the Chamber of Commerce, the Hotel and Tourism Association, and the Marine and Yachting Association. And there's an ad hoc organization called the GPSO in Grenada, Grenada Private Sector Organization. So we all came together for that initiative. One of the things that we did was host member sessions. And even though it was termed a member sessions, we actually open it out to other persons who are not members of the organization because they are also a part of the environment. We had an attorney, much like the process that you took on. We had an attorney come in and we went through the legislation section by section. It takes a lot of time, but it was very important for us to get the views of the stakeholders because you do not want to have a product that only represents a small percentage of employers and it leaves out the majority of persons, because then you're going to get a lot of pushback from people when you're ready to push it through. Everybody would say, wait, but we don't know anything about that. And then the process starts over. Another important thing is that even if you get the support of an international organization like the ILO or a government entity, ensure that the persons who are leading the process, they represent you as a country. They're Barbadians, essentially. Or persons from the CARICOM region, because we have similar legislations. We understand the intricacies of Caribbean life. We understand why certain legislations will be stated in a particular way because of our various industries. And so that is very important. It's important for us to also have a Caribbean voice in the process as well. That is very important. Also, hold your government and government officials accountable. There are instances in where the employers and the trade unions came together in bipartite meetings to discuss the labor code because it was important for us to speak together. And I think that actually helped with issues as we moved on because there's an understanding that, hey, employers don't want to exploit, or most employers, I will say most employers do not want to exploit employees. So let's come together and let's work together. Let's see how we could push this legislation through because at the end of the day, it means that everybody would benefit. And so that is important. That is a key lesson learned for me. So I will say that the entire process, while it's still ongoing, it had employers and the unions gaining an awareness as to what the labor code and what the what the labor code entails, and that is the Employment Act, the Labor Relations Act, and there were discussions to introduce the Occupational Safety and Health Act, as well as add some elements relative to sexual harassment. So quite a lot of work was done. But like I said, the process is still going on. But I do see that there is actually more room for employers and employees representative to dialogue, because I have been seeing instances of industrial disputes popping up from a Grenadian standpoint, which I think could be rectified with more robust social dialogue between employers and trade unions. So that is essentially some of the lessons learned in the process. I'm unable to just exhaust everything because there is so many things just popping up as I'm speaking, but I'm really sorry. Sometimes I get passionate and I go on. So I'll leave it right there. If you have any other questions, I'm fine to answer, but I'll leave that right there. Thank you.
Thanks so much for that, Stacy. So I want to turn it over to Kristin now, right? You've heard the experiences that Stacy mentioned, and I know, as I said earlier, you did the review. If we were to develop a consolidated labor code, share with us what are one or two principles or models that you believe, it could be beyond our original shores, that you believe should form the foundation of such a code.
I think there are so many codes all over the world right now. And I think a lot of countries are going through the process of creating a comprehensive labor code. But I do think, for example, we could follow one of the examples in India, where it is not just one big piece of legislation that speaks to just everything. They divided theirs into four distinct codes that deal broadly with different things. So you can have one that deals specifically with wages and industrial relations, one that deals particularly with occupational health and safety, another one that deals with issues of discrimination and sexual harassment and so on. And you can break it down in that way. And I think that would be beneficial to us, because if you see, we have had, as I said, comprehensive additions to our labor law landscape, and they're so broad, trying to address so many areas and so many deficiencies in so many people, that it would be easier if we just consolidated, into, let's say, four. Another approach that I think is important for us to consider, and this is also to Kamisha's point about enforcement, and whether the code itself might be a solution to our problems. I think in undertaking the process, it is not just a consolidation. It is not just bringing together legislation that is similar. I think it's the natural process of evaluating what is there, determining what you want to keep and what you perhaps do not want to keep, determining what bodies that you want to maintain, what tribunals you want to keep. For example, we have the Severance Payments Tribunal and we have the Employment Rights Tribunal. Do we need separate tribunals? Or do we just need people equally appropriately qualified to address both types of complaints, right? And I think when you go through that process, you can look at enforcement, as Kamisha has mentioned, but also from the perspective of practicality, because you can see everything at a bird's eye view, and you can see, well, there are 300 things that every business has to do. How feasible and practical is that? How can we modify this in a comprehensive way so that it's not 300, it might be 150, and they can find all of them here, right? And then equally, how do we make sure there are not multiple ways of enforcing the same kind of right? So that then it would lead to better enforcement. It would lead to better compliance, one, from a practical perspective of being able to do it, but equally from the perspective of third parties that are created being able to enforce those rights when they're not complied with. right? So I think that would be the best way to approach it. I agree with the tripartite approach in terms of having you have labor, you have employers, and you have government. But you also need a commitment from government to do the practical things that are necessary to support the legislation. It cannot just be, let's have a labor code and put it there. We need to have a complete overhaul of how labor legislation is supported, right? And that again is really to the Labor Department or an entity, a new entity that is created with that purpose in mind. That is a place where employees can come and find out what their rights are. Employers can come and find out, how do I do these things? What do I need to do? Where they can get, as I said, specimen policies and so on. And all of that would support the code and any regulations that go with it.
Thanks for that, Kristin. Each of you, Stacy, Kristin, and Kamisha, each of you in your recent contributions honed in on the fact that the legislation should be fit for purpose. It really should be fit for purpose, right? And when you think about business continuity and succession planning and so on, you also have to consider that same element of being fit for purpose, because how do we continue on for the future? Otherwise, we will find ourselves doing the same thing constantly, having to review, having to fix it. So I want for you to put a lens now on the future, right? So to Kamisha, in an effort to expedite justice, I would like for you to share with us 3 immediate procedural or legislative changes that you would suggest to immediately address some of the challenges that you indicated earlier when we talked about our current state of labor legislation in Barbados. And primarily with the conciliation and adjudication matters that you mentioned.
So I hope the powers that be are listening, because if we can get this right, I think that we will be in a better place. As Stacy indicated, when labor doesn't work, people who are looking to invest may take a backhand approach. I don't know about there because, right? So I think when the processes that are in place in terms of labor is not functioning as it should, it impacts all of us in Barbados. So my suggestions would be mandatory timeframes for the conciliation processes that are truly honored. Because I'm sure the ERA does have timeframes, but right now when they're not respected and not honored, there is no consequence. So timeframes that have consequences attached. So for example, you could introduce statutory deadlines for each stage of the conciliation process. The initial meeting within 7 days of referral, for example. Completion of conciliation within 30 days, those kind of things. And like I said, not just having timelines, but timelines that have consequences where they're breached. Because currently, as I shared before, the conciliation process can be prolonged, leading to delays in resolving disputes. And so by setting clear timelines, parties are encouraged to engage promptly and to resolve matters. As I indicated before as well, the whole idea from the ERA of the Labor Department was to act as a sieve. So that would help too with the backlog. And that brings me to my next point, expansion of powers for labor officers. Right now, it is my view that the lack of powers and the lack of resources are being weaponized by rogue employers. That's my Kamisha's view. And so I think it is high time that we give them, meaning labor officers, the power to make certain decisions. So it may mean amending the Labor Department Act to grant certain officers the authority to arbitrate certain disputes, whether that be unfair dismissal, wage and benefit claims, whatever the case may be. By empowering labor officers to make binding decisions on specific matters, you can alleviate the burden at the tribunal and expedite resolution. And this would be for cases that are straightforward. We all know that sometimes a case is black and white, sometimes. And in a case like that, there should be no need for it to go to the next stage. But when our labor officers don't have the power to say, this is what it is, and if you insist on going up there, there should be then some kind of cost associated with it. That's my view. So that will be the second thing. And then the implementation of digital case management systems. I think that can really help us in getting back on track. So the idea is to develop and implement a centralized digital platform for managing labor disputes. And this could encompass online filing and being able to track your matter, right? Automated scheduling of conciliation and adjudication sessions and real-time updates. I think Kristin touched on it when she said, how do people know when the complaint was lodged? And so the union was able to advocate at least for that. So now when you go and you're lodging a complaint, you get a little paper now stating the date that it was lodged, which officer treated to the matter at that stage. But we need to go further than that. So those would be my 3 suggestions for how practically we can see some improvement with the system.
Thanks for that, Kamisha. So, Kristin, I'll turn to you now. Again, from your experience with the reform, right? The review, sorry. What would be 3 legislative reforms that you would suggest that you could be implemented in the short term, not way down the line, because we need some resolutions almost immediately, right? So for the short term, what are 3 reforms for legislation that would close the gaps that you identified that would not only support the workers, but to support business?
I think we have to start with providing clear empowerment in terms of the tribunal and the department that supports them in the process to get there. I think that is done by identifying key powers that the tribunal must have and supporting that with actually including those powers expressly in the legislation and supporting that with regulations and the rules that they have been working on. Now, they have created 3 different sets of rules, as I understand it, and presented them for consideration, but none of those rules addresses particular things. So first of all, I think the tribunal needs to be empowered, 1, to award costs. And in specific circumstances, particularly as Kamisha was mentioning, where a case is really destined to fail, and on either side, essentially, if you go through a process at the Labor Department where it is not just a meeting where the Labor Department is facilitating, but where there is a basis for saying, but you have no prospect of really succeeding here, and you go beyond that, then you should have to pay the cost of the other person, assuming that they had legal costs to start with. I think they need to be empowered to award potentially interest. But obviously that has to be taken into consideration. That has to take into consideration the failings of the system itself and how slow things happen because of the system. But a power to award interest where the delay in the matter is not so much that of the tribunal itself, but is that of the employer or the employee, right? That is an important consideration. Legislatively, reducing compensation. Right now, there's a power only to award a specific basic award, right? And that cannot be reduced. There is no facility to reduce that unless the payment was a severance payment. So we need to be able to make adjustments which would empower a tribunal to say, well, you are here. Yes, you have succeeded because of some technicality about the procedure, but you contributed so significantly to your dismissal by what you did that we're going to reduce what you're entitled to. Or if there's been loss that an employer has suffered as a result of what you have done, then we are going to reduce the award accordingly. Equally, you have the question of employers not being able at present to do a counterclaim or bring a claim against an employee. And I think if you have an employment rights tribunal, that should be facilitated, because there may be instances, as we've seen in other jurisdictions, where an employee has conducted him or herself in a particular way that has caused loss to the employer. And there's no facilities through the tribunal for that to be set off. Even something as simple as an employee has resigned without giving adequate notice. What relief does an employer have, for example? So I think you have to empower the tribunal that way. Then in terms of the rules that support that, I would certainly recommend that we look at the power to summarily dismiss a case. This is similar to what Kamisha was mentioning in terms of the Labor Department telling you don't have a strong case necessarily, but the tribunal itself should be able to evaluate at an early stage whether it has jurisdiction at all to hear your case. So suppose someone is suing an employer, but that person is not their employer, right? The tribunal must have an ability to evaluate early before anything else is done, whether that person is actually an employer or whether the applicant is an employee, instead of then going into questions of whether there was unfair dismissal or not. That can save time and actually reduce how much of the resources are being used on cases that really might not succeed. Then you equally have, as I said, the power to dismiss. You can have specific procedures and forms that support the Labor Department when an application is being made. You have powers to make interim orders, or even the power that a tribunal may have following a particular procedure to address an interim issue that an employer or an employee may have. So from that perspective, I think that's absolutely critical. Another consideration for the law itself is an amendment to Part A of the schedule. So Part A of the schedule is meant to apply to all instances of dismissal. The concept being that whenever you're dismissing a person, you have to apply Part A. The challenge with doing that is that Part A is framed in terms that speaks exclusively to conduct and misconduct. So you need to adjust that so that then employers aren't trying to turn themselves into pretzels, trying to comply with something that in its basic language doesn't apply to, for example, incapacity, or doesn't apply to a redundancy situation, right? Or even something like some other substantial reason. You have to, I think Part A needs to be broadened to address each of the areas that can be considered fair dismissals. And once you do that, then that will provide some clarity to employers and employees about what is to be expected, so that their rights can actually be protected during the dismissal, or even in the process of discipline, because every form of discipline is not a dismissal, right? And every form of dismissal is not based on discipline. So I think that's another way to do it. The final thing I would recommend is that I think can be done in the short term still is adjustments to critical pieces of legislation like the Employment Rights Act, legislation that deals with whistleblowing, data protection, and so on, that takes into consideration, and even the minimum wages legislation, that takes into consideration smaller businesses and creating tiers for compliance, identifying, for example, minimum numbers of a business for certain of their provisions to apply to them, or breaking down what exactly has to happen if you have less than 10 employees, if you have more than 100 employees. I think adjustments can be made like that in the very short term. I don't think it needs to take a comprehensive review for us to do that.
Thank you so much for that, Kristin. I want to ask you what future trends in global labor law. You know, you're seeing things like remote work and a lot of talk about remote work and platform employment and the use of the AI and so on. Should Barbados anticipate those things, and how can we legislate proactively so that we address those before they become an issue?
Well, I think we have plenty of examples now of countries that have taken those steps. So for example, you have in Portugal where they've addressed issues of remote work. You have countries like Australia that have done similar things. And you can look at what they have done to address something like remote work, particularly because that's something that arose very much out of COVID.
Right.
And our legislation, our Safety and Health at Work Act, to me is inconsistent with the concept of remote work. It provides, it's too broad and can be at risk. The question is, can an employer go into an employee's home and say, well, I have to keep your home safe because that's where you work. Can I go in? What can I do? You know, and then the employee, you know, they want their privacy. How do we balance that? So I think we can look at other countries to do that, but I think we can also look at our social fabric and identify practical ways that we can address the needs of our people. You have gig work, and you also have things like artificial intelligence. And I think we should, at this stage, be looking futuristically at those things. Now, the review that we did not go into too much detail in terms of those aspects, but it did identify them as things that we need to have an eye to, and how we can contemplate in our unique context, how are we going to protect workers from just losing employment simply because of the use of artificial intelligence. And that is a balance that you have to meet, because if it is expensive to have someone do rudimentary tasks, because now we have, of course, you have the minimum wage legislation, and some might say it costs too much money to pay someone to do something that's rudimentary instead of just using artificial intelligence to do the exact same thing. How do you create protections for those employees? Is it that you say that there has to be a consideration for some accommodation similar to what you do with persons under the Persons Rights with Disabilities legislation? Do we have to consider doing it that way? Right? But we have to start having those conversations and identifying what are the risks associated with these emerging trends and how we can mitigate them.
Thanks so much for that, Kristin. So I'll turn over to Kamisha now. From the perspective of workers' rights advocacy, how do we ensure that the modernization efforts, similar to what Kristin talked about, how do we ensure that they do not erode hard-won gains for employees?
So I'm on the same page. Today is a good day. On the same page as Kristin again. I will go a little further. I think she touched on it, but to say we are at the stage now where we can see what is happening abroad. And while a lot of it has not yet come to our shores, it is high time that we ensure we put the right protections in place. So when it comes to technology, for example, just the other day, I traveled to Europe, and it's everywhere now, but not quite at home in the fast food chains. Very few employees there now, because you come in and you order on the screen and you pay there too, and you just have to wait for the food to be given to you. So when you think of those things, if that was to happen tomorrow in Barbados, so many people would be displaced, because that sector, that restaurant sector, accounts for a large part of our workforce. And so before anything like that happens, we need to be thinking, how can we give these workers the power and how can we enfranchise them so that should these things happen, they have other avenues. So the reskilling conversations, and not just conversations, but we need people who are going to actually put some money behind those things, because that is the future of work and that is the reality. And then when it comes to the gig work, we need to be having the conversations around how do we protect the workers' interests, because you're hearing more about surveillance. Now, what does that mean? Sometimes the device that you're given is being monitored, or they are going as far now as to you no longer having a human being make decisions on dismissals, but really and truly the technology decides. Those are things that we can see happening abroad, and we need to start putting legislation in place to kind of direct how these things can happen in Barbados. Because if we don't, and those things come to our shores without direction, then our social services net will be severely impacted. So definitely agree with Kristin. We need to be having those conversations now. We're a little behind, and that's a good thing in terms of the technology being here. So we have the capacity to put the relevant safeguards in place so that when things do approach, we are prepared.
Thank you so much for that, Kamisha. So at this point, I want to turn it over to the audience for some questions, right, that they've posed to you guys. So I'll read them for you. The first question is, would it be feasible for the Small Business Association and or a Micro Business Association to maintain required registers on behalf of these small business owners, so that they can be compliant without it being onerous?
I think the challenge with that is that someone still has to provide the information that goes into the registers. So even if you do have some third party do that, or even a specific body that's created for that purpose, you have to contemplate that the employee still has to provide the information. So I think that the employer still has to provide the information. So the solution may be twofold: yes, to provide that type of support, but equally to reduce the number of registers. Right? Just identify what really is the most critical information and why it is required, so that then you're reducing the number of areas for compliance, and then adopting again a tiered approach in terms of the type of business that's required to maintain certain registers. If you have a very large business, you should have a human resources department, and that department can take on the responsibility of gathering the information and maintaining it. But if you have a small one of about 5, then you should only have the most essential and absolutely required registers to make sure that the 2 or 3 employees that business has are safe.
Thanks for that, Kristin. So one of the members online, they noted, if not a labor code, what are the top 3 reforms the union would like to see? I think you kind of touched on that. Are there any more that you would like to explore at this time?
I mean, there's so many, but the ones that I mentioned to me are the most critical ones. Those are the ones that impact workers every day. So I would, yeah.
Right. Okay, thanks. Kristin, one of our viewers, they asked this question: what are the overlaps in legislation causing the most confusion? If you were told to pick one to fix, what would it be?
I actually think the biggest overlap. I think it would have to be in the functionality of the tribunals. I think the access to justice for employees and the prompt resolution of it for employers, I think is critical. And I do think that we really only need one tribunal to address all of the issues. So the overlap in that instance is having multiple tribunals to deal with multiple issues, and then having different rules for them to apply, being, for example, the Severance Payments Tribunal, the tribunal created for persons with disabilities, as well as the Employment Rights Tribunal. And I would create one tribunal, which would then be applying one set of definitions for employer and employee, and would be determining each issue as it arises.
Okay, thanks for that. And either Kamisha or Kristin, you guys can answer this. With regards to national duty, given there is no law, they're asking for your thoughts on whether it should be paid or unpaid.
I think that's the one time we get disagree.
Okay. And I'll answer this, I guess, because a lot of national duty is sport related. There are other areas too, but I think a lot of people think of national duty when you represent your country. And I think that's important. I just don't necessarily think the employer should be the one paying for it. I think that when we ask people to represent our country, that we should be having the government pay the employee when they travel. And every association is different. So you may have a small association. That association does not have the money to pay the people they're selecting, the coach or the employee. But the government wants us to be properly represented, I would think. And I think the employee should be paid by them. And the reason why I say that instead of businesses is because, again, every business is not the same. And you might even have a big business with small margins. And I might not be able to afford to pay you for the 2 weeks, it might be 2 weeks, it could be 4. If you go to Commonwealth Games, that's a 3-week trip and it's not a vacation, right? I went to India in 2010. That was not vacation, it was far. And when I came back, I was tired, but I had to go back to work, right? And the business might not be able to support that. Equally, what about those who are self-employed doing national duty, right? They lose income. People have had to make decisions where they say they are not going to represent Barbados because they can't afford to leave, right? And funny enough, it's those who are self-employed who might have the most flexibility to train to represent the country. So I don't think employers should be required to do that. I don't think it's fair and reasonable to them. But I do think that it is necessary that employees still be paid when they're making that sacrifice for their country, and that should come from the government directly.
Thanks for that. Either of you can.
Oh, Kamisha, don't say whether she agreed or not. I am keen to hear this answer now.
Okay. No, if I had to answer the question first, I would have said yes, that employers should pay. However, I am swayed by Kristin.
All right.
By Kristin's approach.
This is a good name.
Because I do agree.
Balanced,
It sounds balanced, it sounds fair. You are
Balanced.
representing the country.
Yeah.
Wow, things are looking up.
This is exactly why we should proceed with the labor code, because we can have a discussion. But look
Yes,
at
I
this.
make sure it works for both
Exactly.
parties. Correct.
If we proceed with a labor code, it would be a comprehensive evaluation of labor law in Barbados. And I do not think we might be on opposite sides, but we all have the same aim.
Yeah, we can find a middle.
Yeah.
Right? I think we can
Yes.
find a middle ground that works for everybody.
Correct.
So you see?
I mean, I would say this was probably one of the easier issues to determine, but yeah.
All right, so thanks, ladies, for that. Right. We have Barbados today in the room with us, and they have a question also. Would you like to go ahead and share the question?
Well, first of all, apologies for my tardiness. I just merely wanted to find out what were some of the complaints that have been coming to me before. Yeah,
From whom? The employees or employers?
both.
From both. Okay, so I will repeat the question for those online in case you did not hear her. So her question was trying to determine some of the key complaints that are received from both employers and employees.
Okay, so I guess I'll go first. When we did our evaluation, I think we did try to get information from employers, and particularly through the Barbados Employers Confederation, to see some of the main concerns. And a lot of the concerns did relate primarily to small and medium-sized businesses not necessarily having enough support, feeling like if they don't even know what they're supposed to be doing, and even if they know, they really don't have the resources to do it. So you would have a small business, you have employees. You don't want to fire the employee. You just want to warn them, but you're afraid that if you do that without having a meeting with them, having a representative who may or may not be a lawyer, that somehow down the line, if they still don't correct their behavior, you won't be able to fire them properly, right? So I think that was a significant concern. Then the actual disciplinary process itself, feeling like if it was so almost hard to comply with, and needing more clarity on how to do that in situations which are all disciplinary in nature, particularly something where you have an employee who is unable to work for an extended period of time because of some type of injury that they got on the job or otherwise, and they're out indefinitely. But you have to figure out how to replace them. You have a difficulty finding people who are willing to work without a certainty of period of employment. But the law says that you can't dismiss this person unless they've been away from the business for a continuous period of 12 months or 12 months out of 24 months. And feeling like if they weren't sure how to navigate that and they didn't have enough support to do it. So those are the types of complaints that we got, and particularly the absence of support outside of the law itself, just to help them know what to do and how to comply. Feeling that the Labor Department was focused all on giving whatever support to the employees, and they didn't have anywhere to go.
Yeah. One major concern for employees is union busting, so to speak. So employees are concerned that when they choose to exercise their fundamental right to associate as they wish, some employers are trying to hamper that, whether in their message to them or in how they treat to people who have come out as being associated with the union. So I think that too is an area that may need some kind of reform and some teeth. Because as much as, we try to tell Barbadians, you're entitled to join a union of your choice, when it comes down to the reality, a lot of workers are fearful because of how they're treated at work. So that's one. In terms of the legislation and the fall away from the legislation is the delay issue. That is a critical one because justice delayed is justice denied. And for a person, for example, who was terminated unfairly, from conciliation to a decision at the tribunal, if it's not settled, can be years. I don't think 5 years would be. I don't think anybody in this room would contest that up to 5 years, right? So that is a real major problem. Another one is the compensation. So after I wait the 5 years, then the compensation remains the same. Like there is no, as Kristin was saying, there is no interest being garnered. There is no costs, extra costs, no loss of wages. None of that is applicable. And so I would say those are the three main concerns for employees.
So thanks so much for that, ladies. I want to turn over to Stacy for her she wanted to make a comment, and then we'll let you guys do your closing remarks in the interest of time, and then we'll wrap up the discussion. So go ahead, Stacy.
Oh, thank you. I was happy that Kamisha brought up the conversation about union busting tactics, because one of the things that Barbados can learn from Grenada is that of recognition of unions. I know currently Barbados have their Trade Unions Act, but it doesn't specifically it speaks to registering of unions, but it doesn't speak to recognition of unions. It's not something that is legally enforceable. So to add to what Kamisha is saying, maybe that might be something that Barbados can consider. Are you going to place in legislations a mandatory clause that employers should recognize the union that has the majority within the workplace? So I think that might be something for the unions and employers to think about as a reform area.
Thanks so much for that, Stacy. We have Kristin here. She wants to make a response to your statement. Go ahead, Kristin.
Yes, that's an excellent point, Stacy. And as Kamisha raised it as well, and that was a part of our evaluation as well. We did make extensive recommendations regarding recognition of trade unions, and whether it should just be a question of 50%, and what is the question in terms of recognizing more than one trade union in an organization. I think that's very, very important. And the trade union activity in any organization is important, and to be able to properly recognize them is equally essential. So hopefully some of our recommendations will be considered as far as that is concerned.
Thanks so much. So I'll let each of you ladies give your concluding remarks, your closing remarks. I'll start with Stacy. I'll start with you first, and then we'll go to Kristin and then Kamisha.
Okay, so I would like to thank the BEC for allowing me to be a part of this discussion to share a perspective from Grenada. Like I said previously, there is so much to unpack and I had to be mindful of the time, but I do think that legislative review is very important for our country because we're living in a dynamic environment and things change. We have AI, we have remote work, as you said. We need to make legislations that can move with the time and legislations that would attract investors as well as ensure employee well-being. So I thank you so much for the discussion. I really enjoyed the contributions from the other panelists. It's really a lot to think about, and I do hope that the business community as well as unions would use the opportunity to cultivate more discussions on this topic. Thank you.
Thanks, Stacy. Kristin?
It really has been a pleasure to be a part of this discussion. I am grateful to the Barbados Employers Confederation and to the International Labour Organization for giving me the opportunity to evaluate the laws of Barbados and make appropriate recommendations. I've been grateful for being a part of this panel where I could see how the process was applied in Grenada, but also see the perspective of the unions as well. At the end of the day, labor has to be for everyone. We all benefit. Whether you are an employer who is looking to expand your business or you're an individual looking for employment, the system needs to facilitate you. And as a consumer, it needs to facilitate everyone. So I think we have identified several areas that really need to be addressed. I think we urgently need to bring together the stakeholders to discuss the comprehensive review and reform of labor in Barbados by way particularly of a labor code. But at the very least, do some of the things that we did today and highlight the top 3 that can be dealt with now and focus on those.
Thanks, Kristin. Kamisha?
So I also want to say thank you to the BEC for hosting this forum. Just from listening, it's very clear that we all have similar interests or even the same interests, and we are all plagued by the same concerns. And as a trade unionist, I hold the firm belief that our duty and our mission is to not only protect the interests of workers today, but to shape a labor landscape that is inclusive, adaptive, and resilient for tomorrow. And so it's only coming out of these kinds of discussions that we are able to do that. So hopefully this moves beyond the sphere of just a conversation, and we can actually see some action as we move forward. But I really enjoyed the session, and thank you.
Okay, thanks for that, Kamisha. I want to thank you all for your thoughtful and insightful contributions to the discourse today. Let's take today's discussion as a stepping stone towards a more robust, fair, and adaptive labor framework for Barbados. I want to thank the audience online for joining us today, and I hope you have a great rest of today.
Thank you.
Thank you.
When you cut the tail, you did.